Welcome back, ladies and gentlemen, to yet another episode of Lassiter Law, here with my co-host, Lacey G.
Hi there, Mark Lassiter.
Hey, so today I wanted to talk about a case because we're all about practical application here. So today we're going to talk about how we used, kind of like the last time, an ALR to win a DWI case. And today's topic is going to be more about motions to suppress.
Okay.
So let's just talk about in general. If I were to say, Lacey, what is a motion to suppress? What would you think as a normal layperson?
To suppress is to keep it out of the public. You would want them not to have the information, right?
That's exactly right. So think about it in terms of law. If we're titling a motion, it's going to be titled motion to suppress. Then we're trying to keep something from the jury.
Okay.
Right? Or if a TBC, trial before the court, before the judge. We say this evidence should not be used for whatever reason. Now, most of the time, it's because there's a violation of some sort of right that the citizen has. We call that the Fourth Amendment, like search and seizure law. Search and seizure law is quite possibly, if you're a criminal defense attorney, the most important aspect of the Constitution that you need to know inside and out. And I find time and time again, lawyers don't know it. The lawyers don't know it because the last time they heard it was in law school, right? And then you get these lawyers that ask all the other lawyers, hey, I've got this issue. Do you think I should do something with this? And you're like, how do you not know that is a suppressible issue? That evidence now will not come in. And if you can prevent that evidence, depending on what it is, sometimes you win the case.
Okay.
And that's why we talk about how important the ALR is. And then you use the ALR, which is a civil proceeding, to win the criminal case by doing a motion to suppress, which is a criminal proceeding. So that's the difference. So we use the one to win the other. And if you missed our ALR episode, go back and look at it on why it's so important to do these ALRs and why it's so important to ask these questions. Because when we do the motions to suppress, what you're saying to the judge is this or that piece of evidence is not legally admissible and it cannot be considered. And then you follow up with, if that evidence cannot be considered, depending on what it is, then that item, whether that be a blood test, whether that be the probable cause a lot of the time, the reason for the stop most of the time, then the entire case is thrown out because everything that is what is known as fruit of the poisonous tree. So everything from that moment forward gets thrown out.
Because it didn't happen. So this is a motion to suppress, but the judge still has to rule on it and can't say yes or no.
The judge still has to rule.
Okay.
And sometimes you lose motions to suppress, and then you can reintroduce them in front of the jury. So before we go into the practical application, let's talk about just in general, when do you file a motion to suppress? And there are competing theories on this. A motion to suppress can be filed at any time prior to trial. In fact, most of the time, I do my motions to suppress prior to trial. So we will have a separate and apart motion to suppress setting. That's all it is. And we're there to discuss the suppression issue, whatever it is that I'm trying to suppress, whether that is there was not a reason to detain, therefore the rest of the case gets thrown out. There was not a reason, or the basis on which you drew the blood was incorrect, therefore the blood is thrown out. We're talking about DWIs, but it can be for anything. For a drug case, the way in which you searched the vehicle and got to the drugs was illegal by the cops, therefore the drugs are thrown out and you have no evidence. Most of the time, I like to do my motions to suppress prior to trial. If I do them prior to trial, Lacey, what ends up happening is the judge can grant or reject, deny that suppression request. That suppression request then, if it is granted or denied, can be appealed. Now, it can only be appealed by one party. That's the state of Texas. So the way the government works is they don't play fair. So with criminal defense, if, let's say, I win the motion to suppress, So Lacey, I'm representing your friend, right? And you talked about your friend the other day on one of the previous episodes that got a DWI. That friend, let's say the officer says, violated the law of speeding. Therefore, I'm able to detain this person, and I smell the odor of alcohol and bloodshot eyes, and then I investigated for DWI. Well, that speeding, let's just say they didn't catch it on radar or LiDAR. They caught it on what's called pacing. Pacing is when the officer tries to stay the same distance behind you for a certain amount of time, and then he looks at his speedometer and says, I know the person was going 55 and a 40, right? All right.
That's scary. I didn't realize that was a thing.
Oh, yeah.
They could just follow behind you going the speed limit.
Oh,
which if someone's behind me,
well, they
then
don't
that
go the
makes
speed limit. You see, they can't go. They have to go the speed that you are going. Then they calculate what your speed is, and then they say the speed limit was X, so you went over that, right? If they don't have a working LiDAR or a working radar, then that's what they do, which sounds kind of BS, right? You're like, wait a minute, the whole purpose, your car is equipped with a little dash thing so that we can see that shows your speed was X.
And I slow down if anybody's behind me, beside me, cop or not. Then I feel like someone's trailing me, and it makes me automatically slow down anyway.
Right. But you just think about it in terms of this. If that were the case, and your friend was like, and they were clearly guilty of DWI because their blood test was 5 times the legal limit. They looked like, and they said they were drunk. How do you win that case? Well, sometimes you find something from which you can suppress. And if I suppress the stop in that instance, the original detention, then everything else is thrown out and I win the case. So we would do a motion to suppress prior to trial on the speed, whether or not the officer had the right to detain you. And in this motion to suppress, I get to ask the officer questions about his experience with pacing and how long was he behind the vehicle, and did he actually get to the vehicle same speed, and how do you know you were going the same speed, and time plus this equals distance, or time plus distance equals speed. And we go into the equation, and the officer doesn't understand it and doesn't explain it properly. And let's say the judge grants that motion to suppress, right? We have won, right, Lacey? We're done. We won the DWI, case over. No, sir. What happens next is the state, the government, gets to then appeal your decision. It's not a final disposition. They have 30 days to do so. So let's say they decide to appeal the decision, then it goes to a court of appeals, which by and large, they want to support the judge's decision if they can, unless it's under an abuse of discretion. Usually it's under an abuse of discretion standard, but sometimes it's de novo, which means they get to look at all the evidence. And in that particular instance that I described, they would look at all the evidence and they say, is there enough evidence to support what's known as reasonable suspicion, the lowest burden of proof in the country? And many times the Court of Appeals will reverse the trial court and say, no, objectively, there's enough evidence here to substantiate the officer's belief. And this is where it gets crazy. For reasonable suspicion, the officer just has to have a reasonable belief that you violated the law. You don't actually have to violate the law. He just has to have a reasonable belief that you did, right? And it has to be based on specific articulable facts. So if the officer says, because I was going 55 and I caught up to them, even if the judge doesn't believe him, this Court of Appeals can say, no, based on the evidence that we have, we think there's objectively enough evidence there. And then you lose and you're right back at it, which is the second time a person can bring a motion to suppress, or the second instance in which the strategy is different is that you bring it during the course of a trial. If you bring a motion to suppress during the course of a trial and the judge rules for you, then the evidence is suppressed and the jury is directed to find your client not guilty, then there's no way to appeal. So some lawyers, they decide, hey, we're only going to do motions to suppress during trial to take away the state's ability to appeal. Now, that's a strategy, but let me tell you, there's a harm to it. And I know many wonderful lawyers that employ this strategy and they tell their clients, no, we are not going to do motions to suppress prior to trial. We will do them during trial. But let me ask you this, Lacey, just practically speaking, if you were a sitting judge, just think you're a normal person, you're a judge. You don't have to know anything about the law. You have a jury seated that you spent an entire day picking just to make sure that you have enough citizens. The citizens came out. Everybody had a chance to talk to the citizens. Now you have a jury seated in the box. We call the jury box the box. Do you think the judge is going to be more or less likely to grant your motion to suppress, considering that you went to the time, effort, and trouble and money to put a jury in the box?
I think they would not, if there was time to do it beforehand, and to that just allows you to outweigh all your options before you go to trial, right?
It just seems to me, and I would agree with you 100%, that it seems to me that the judge would be less likely to want to grant your motion to suppress in the event that they have already spent time, effort, energy, and money to put a jury in the box. They'll just say, let's let the jury decide. Because you can also do what's known as a 3823. That's Code of Criminal Procedure 3823. And what it says is that you can raise the issue, the motion to suppress issue, in front of the jury. And the jury can decide if there's enough on a factual basis, not a legal basis, but a factual basis, if there's factually enough information to support reasonable suspicion to detain, or probable cause to arrest, or whatever else that you're bringing in front of the jury. So the judge might be more likely to do it for that. So I look at the lawyers who employ that strategy and I say, I understand why you're doing it, but also understand this. You have given up the opportunity to win prior to trial. And what that means is the client has to pay for a trial. Now, Lacey, every lawyer is different, but a trial is going to be more expensive than a motion to suppress. In every instance, a trial is always going to be more expensive because it involves more time and the lawyer is going to charge more for that. So why wouldn't we want, going back to what kind of a lawyer do you want to select? The lawyer should explain all of this and your options to the client, let the client decide, and then give them the pros and cons of each, which is what I do. But I always advocate more bites of the apple, right? Why does that saying exist? Have you ever heard that saying? Take as many bites of the apple as you can?
I have not.
Wow, I must be really old. Okay, so that saying exists because you want as many shots at victory as you can get. So if I'm looking at a case, Lacey, and I say let's say in that example with your friend that we did, if I can do a motion to suppress prior to trial, let's just say we lose it. Then we move on and I can do that same motion to suppress in the trial. But what advantage have I gained by doing the motion to suppress early? What can you think of?
That you already gave the judge time to answer and then they're going to leave it up to the jury?
No. We're talking about if I were to do the motion to suppress for the pacing, the reasonable suspicion to actually detain them prior to trial, and then let's say we lost that motion to suppress and that case goes to trial, what advantage have I gained by doing the motion to suppress early?
That you already know the answer.
That's exactly right, because I got the officer's testimony. You see, now I have sworn under oath testimony, which the officer then gave, which should be truthful, which they then, depending on if it's he or she, has to abide by. They have to support that same testimony in the new trial that you're going to do, and they may have screwed up. And that leads us to the perfect example. So we had a case, practical application. We talk about this all the time. I am all about practical application, ladies and gentlemen. This is how you do it. This is how you put it on the whiteboard and draw it up. Sometimes it works out perfectly, sometimes it doesn't. But the reason that we do it this way is because of situations like this in which it can and in fact did work. So the fact pattern in this, Lacey, all right? And I brought this case because we just got a dismissal in this case. The DA said, that's it. right before trial, they handed me a dismissal and they said, we don't want to go forward. They didn't say I was too good, but in essence, they said I was too good.
High five.
All right.
Right here, Mark Lassiter.
All right. So the facts of this case, and I'm just reading them off to you. You have an officer that was dispatched at 2:45 in the morning. So we know it's after the bars close, right?
Mm-hmm.
2 in the morning is when the bars close. We know we're looking for DWI drivers. So the officer is dispatched at a 911 call. 911, 2 separate 911 calls said we passed a car in the lane of traffic right before a train tracks that has no lights on and appears to have a person asleep at the wheel, right? Instantaneously, what are we thinking? What is anybody going to think, Lacey? Drunk, right?
Drunk, sleepy.
Passed out behind the wheel. That's exactly what people are thinking. Keep in mind, in a trial, the jury would hear from 2 different 911 calls describing a car that has not moved, meaning it's been there a while, right before in a lane of traffic with car and drive that looks like it has a person passed out. So we're thinking we got a passed out drunk driver, right? All right. So they get there. The officers get there. There's multiple officers. They get there. They knock on the window. They cannot wake the driver up at first. So they make sure they put their cars in front of the car. So in the event that the driver wakes up and decides to drive away, it can't.
Okay.
Right? So they position themselves correctly. Then they get the driver to roll down the window, and they instantly are greeted with the strong odor of an alcoholic beverage, bloodshot eyes, and slurred speech. When asked whether or not the person had been drinking, the person responded yes. She said she only had 1 margarita, right? But when they made contact with her, she thought it was midnight, and it's nearly 3 in the morning, right? So the time is quite a bit off. Now that's due to sleeping, but it also indicative of a person maybe doesn't have all the normal use of their mental or physical faculties, right? So then when they follow up, she does the field sobriety test. She does very poorly on them. And then she keeps asking why they won't let her go. Again, indicative, after failing to be able to stand and walk normally, even outside of the field sobriety test, the person did not look or did look intoxicated. Then they did a blood test, and they found out she was a 0.16 blood test about 2 hours after the stop, indicating that based on the admission of 1 drink, that wasn't true because it takes more than 1 drink to be a 0.16. But here's what we do, right? That's the information I'm working with. It doesn't sound good. This person is about to be a nurse. And if she is going to be a nurse, this will hinder her from getting her nursing license. So she has to win. And it's in a bad county. It's in a county that is known for being very difficult with DWIs. So how do you win that case? Well, first we did the ALR. And in the ALR, this is the information that we got, right? And understandably so, we asked why they were detaining the person. In other words, why would you detain the person that is simply there, that is in a vehicle, that is stopped at a train tracks and sleeping behind the wheel? Why did you detain them? Mm-hmm. Now, the answer for the officer should have been the community caretaking privilege, which allows them to detain in certain circumstances to check on the welfare of the citizen. That's not what they did. And here, they said she was detained as a possible DWI suspect at the point where I saw her asleep behind the wheel. This is direct. This is an under oath testimony from the officer in the ALR. Again, we do these ALRs to find out exactly why, so we can pin the officer down and saying, this is what you said. Mm-hmm. So she didn't say community caretaking. So she's not concerned with welfare as a female officer. And she said she was detaining for DWI at the point where she saw her asleep. Now, why does that matter? Let's just think about it. Attention to detail. Why does detaining for DWI at the point that they saw them asleep matter?
Because they're assuming that something happened. They're assuming that this is under DUI and not under something else.
That's exactly right. Ladies and gentlemen, Lacey said it. The officer is assuming we got a DWI. Now, that assumption may not be wrong, But when you make that assumption prior to making contact, we don't even know if alcohol's involved. Now, we may think it, but we don't know it. And so then you pounce. At that point, the window is rolled up, correct? When I'm asking the officer, yes. And you've had no interaction with the defendant other than they are at the railroad tracks asleep inside the vehicle, correct? The answer was correct. At that moment in time, you commanded her to roll down the window. Now, why is that important? Because we must first establish this is a detention. You're not allowed to disobey a command from the officer. Therefore, it is a detention by the officer. And it wasn't, I asked, it wasn't a request. It was a command. Correct. So now we've established it's a detention. We've also established full police uniform, sidearm holstered, all indicating to a reasonable person they're not free to ignore the request. We've established the detention. That's the first part.
Mm-hmm. And they had the car cornered
They
off
had them
as
blocked
well,
in.
so you can't even.
That's right. You can't leave if you wanted to.
Yeah.
So we have the detention. And I go back to, so what crime were you detaining her for at the moment in time that prior to rolling down her window? And her answer, prior to rolling down her window, when I saw her asleep behind the wheel, I was detaining for a potential DWI. Then I followed up. Okay, even though you had no information she had actually drank, you were detaining her for DWI, correct? The answer was correct. And here's what a good attorney will do, right? Because right now we know the person's detained for DWI, and we know that if they wanted to, they could say there are specific articulable facts to indicate to me based on the time of night, being asleep behind the wheel, no apparent reason for being asleep, that they could point to certain things and say this person is intoxicated. You've got to nail them down. You can't just let them go with, all right, you were detaining just for DWI. So I follow up. And I said, would it be fair to say at this point, because you don't have any information regarding drinking, it's more akin to a hunch that she is intoxicated? Would that be fair to say? And the answer was yes. Now, the officer could say no, but the officer said yes. Now, Lacey, in the law, we do not detain based on a hunch because that is not a specific articulable fact. A hunch is exactly that, a feeling, an emotion. It is not a legal, specific fact that you can base a decision on. So now we have gotten them to the point where they have agreed they have no real reason to detain. Now, could they have obtained for obstruction of a passageway? Yes, they could have. Could they have obtained for the community caretaking privilege? Yes, they could have. But this officer was young. And because I saw that in the ALR, I was able to ask questions, not to trick them, but to nail them down on what the truth actually was. And ladies and gentlemen, we are after the truth, and you don't get it if you wait until the trial. Why don't we get it? We don't get it because the state, the prosecutors have had a chance to talk about the evidence with their officer and say, this is what we need you to say. Now, they may not say it in those words, but they're going to go over what they believe the facts are going to be and what they believe the strategy of the defense will be and how to overcome that strategy.
So, question, in this case, did you suppress and have that denied and then you brought it up at trial?
So in this case, what we're going over right now is just the ALR.
Okay.
So we haven't even proceeded to trial. This is right as soon as the license gets taken, and then they are attempting to suspend the license. So we have now established in a civil hearing what the facts are, which is really important because we're going to use those facts later on. You're going to see how we did that, right? So we're not just about tooting our own horn here. We are using this as an example of what you should do. How do you win the unwinnable case? You follow the process, and the process must be perfect. You must have attention to detail because this could have been missed. If I had stopped at, hey, you were detaining for DWI, none of this matters. It matters because now they followed up and said, this is in fact a hunch. There's no community caretaking. There's no obstruction of a passageway, and that's going to matter here in a second. All right, and I followed up after that, and I said, so you were just going off the hunch, But after she rolled down the window, that's when you had reasonable suspicion to confirm your hunch. The answer was correct. So right there, we have now nailed down the officer. There was no reasonable suspicion prior to the detention. Then after the detention occurred, that's when you gained the right to detain, right? This is a simple one, right? It's black and white. That's what the officer said. We should then be able to utilize this to win the motion to suppress, right? I mean, the law is the law. It doesn't change. If you win the ALR, which is based on the same law of reasonable suspicion that a DWI is in a criminal court, the judge should not make a different ruling. And this is where it gets really crazy, because we won the ALR because the judge said, you're right. If the officer says there's no reasonable suspicion to detain, and the officer says, I only had a hunch prior to, even though there's other reasons why you could have, the officer didn't articulate those. Therefore, there is no right to detain and you win. We should win across the board. Easy case. No, that's not what happened. So then we raised the issue in a motion to suppress prior to trial. Now, ladies and gentlemen, if I had raised this in the trial like I started with, yes, the state doesn't have a right to an appeal based on what the judge decides in that moment. But I want the judge to be the most likely, the most friendly towards granting the motion to suppress. And in my opinion, that is done prior to trial. And it gets you another shot at the apple. And this is where this is going to matter. So we do the motion to suppress. When we do the motion to suppress for this case, we go over the same things that we discussed in the ALR. So I have the transcript from the motion to suppress. Short circuit, giving you the end game here, but it was denied. And how can a motion to suppress be denied when you won the ALR on the same issue? Well, let me show you how. Because this is what happens when the officer has a chance to talk to the prosecution. So first we talk about when you have a chance to cross-examine the officer, and you have instances where you know that they have given differing testimony. You start with establishing the simple things, the things they can't get away from. So we talked about the ALR in the motion to suppress. And I asked the officer, did you give ALR testimony? Okay. And that ALR testimony, which is the administrative license revocation, which was under oath, the same that I just read to you, that was closer in time than it was to today, because the motion to suppress happened about a year and a half after the ALR. Now, why is that important? Well, because the ALR was closer in time to the time of the incident.
Because that happens within weeks,
Happens within about 3 to 4 months.
Okay.
That incident is now fresh on the officer's mind during the ALR process. Do you know what it's not fresh on? A year and a half later. Mm-hmm. So we established that instance, the ALR, was closer in time than it was today. Yes, that's an absolute. So this instance would be fresher on your mind at that time, the instance of the DWI, than it is today. And the answer was potentially. Well, that's garbage. And ladies and gentlemen, lawyers don't accept that answer. What are you doing? Potentially? There's no potentially here. Mm-hmm. It's closer in time. It's fresher on your mind. No right person in their right mind remembers something better a year and a half after the incident that they did a few months after the incident. That's just straight garbage, and don't let them get away with it. Lawyers do. They just move on. Screw that. Did you give an oath as part of your testimony there? I did. And were you truthful in your testimony? Yes. Are you being truthful today? Yes. Then you cannot say with any degree of truthfulness that you remember it better today than you did when it was only a few months after the incident. And you stomp them right then and there. You make sure that judge, and if you're doing it in front of the jury, that jury knows that officer just straight lied. Don't call him a liar. People don't like people who call officers liars. Mm. What you do is you illustrate that they're a liar. because the officer is willing to lie. And then what do you think that I do next? And the only thing that has changed in your allegedly truthful testimony between then and now is that you've had a chance to talk with the government. Lawyers frame the state as the government. They are not people representing you, the people. When the DA gets up and says, I represent you, the people, I'm the lawyer that you guys hire. No, they're not. And the way to challenge that is you get up in front of the jury and say, if you get in trouble, is that the person that's going to represent you or the person that's going to prosecute you? And they say, that's the person that's going to prosecute you. Then they aren't your lawyer. Don't let them act like they are. They are out to get convictions, not promote justice. That's what we're here to do. And you can get on your high horse when you say that. And you can say that because you're going to have an instance like this where, Lacey, if I say those words, let me ask you, do you think that that's powerful? If I go, you were being truthful over here under oath, and then now you're saying something different. If the only thing that is different between then and now is the fact that you've had a chance to talk with those government lawyers over there, do you think that the government looks like they're truthful people?
No.
And then I always follow it up with this, and it's a joke, right? But you want to make the jury laugh a little bit and understand what you're saying. You follow that up with, and the government's always honest, right? You ask the officer that. Because if you say it in that tone of voice, and the government's always honest, right?
Mm-hmm.
Because now you've insinuated the government is dishonest. Now prove it. The jury knows they're dishonest. Prove that up for the jury so the jury goes, ha ha, but yeah, we're thinking these government lawyers, they're shysters.
Mm-hmm.
Let the jury see it. All right? Now, if we're doing this was in front of a judge. Judges are not always fans of the antics. They're especially not fans of my antics. But I do them for a reason, so that I can illustrate a point. In this case, it was to a judge. So the antics, you tone them down a little bit. You don't have to ask that extra question. The only thing that has changed. But when we ask those questions, it's because if it goes to a jury, I want that answer. And I want it under oath so that I can get a transcript like I'm reading to you from to illustrate the difference. All right, so let's move on a little bit. All right. Did you see any crime taking place prior to your interaction with the defendant? Your testimony was, I did not. Did I read that correctly? Yes, you did. And were those your words? Uh-huh. And were they closer in time to the time of the incident in that case? Yes. And the only thing that has substantially changed between that time and the time that you gave truthful testimony and the time that you're testifying today is you've had a chance to talk to these prosecutors, right? That's the only significant change. That's right. Boom, we've got them, right? It doesn't matter that you lose the motion to suppress. This is gold for your trial. Okay. Then I follow up with, now keep in mind, what was the original reason for detention, Lacey?
They were asleep behind the wheel.
No. What was the crime that they were detaining for? The officer. What did she say?
Suspicion.
Suspicion of what?
DUI.
All right. So suspicion of DWI. That is the crime that they were detaining for. So my question, after having a chance to talk to these prosecutors, and you always look at them, prosecutors, you have now changed your opinion and said, I saw a crime, it was obstruction, meaning obstruction of a passageway. Now, Lacey, you're just a lay person, not just a lay person, but a lay person meaning not a lawyer. Is obstruction different than DWI?
Yes.
Right? It's got its own crime. It's got its own elements you have to meet. So why then do we hear that a person initially, it was only DWI? That's the only thing, I read it out. That's the only thing you suspected prior to detention, yes. And it was based on a hunch, yes. Now it's they obstructed a passageway. And it's because they talked to the DA and the DA said, hey, you need to say that. All right. So after talking about a few things regarding some other things that they had changed in their testimony, all right, we went to, and what was she being detained for? We always kind of come back around. At that point, obstructing a roadway. Have you ever said something different? And the officer goes, I do not recall. Keep in mind, this is an emotion to suppress. Now, I've already challenged the officer once and said, that's not right. So she knows, the officer who's testifying was a female. She knows that she said something that was different. So I give him another chance. Hey, because what I want to establish in the motion to suppress is that this person was detained based on a hunch. That's what I have to get to, Lacey. If I cannot establish to a judge that this was a hunch detention, then I lose the motion to suppress because it's based on reasonable suspicion to detain. So I need to get the officer back to their original statement. So I keep coming back to it after ridiculing the officer, saying, look, you know you changed your story. You know it's because of these DAs. I come back to it to give them a chance to change it back. Because if they change it back, I should win, just like I won the ALR. And then we win the DWI potentially. So I come back with it. And she was detained for what? She stuck to her guns at that point, obstruction of a roadway, because that's what the DA told her. Have you ever said something different? When the officer says, I do not recall, ladies and gentlemen, walk up. Lawyers, walk up with the ALR transcript in hand. Have it ready. If you're attention to detail like I am, you have it highlighted, you have it notated, you know exactly what the officer said. In fact, you probably asked the same exact question that you asked in the ALR so that there can be no confusion over the response. So I read the response. Never let the defendant or the witness read what you are showing them. You read it because you are the more powerful reader for effect. You ever heard that? They get actors to do these readings of a book, like a Bugs or the Peter Rabbit or whatever for the school. Mm-hmm. That's what this is. You are reading it for effect. You are reading it for effect for your judge or your jury. And so I read it. And at that moment in time, what crime were you detaining, if there was one? If, in fact, there was a person inside the vehicle, your answer was she was detained as a possible DWI suspect at the point I saw her asleep behind the wheel. And I go, did I read that correctly? Because I'm showing them as I'm reading. Yes, and I would agree with that. What? And so I follow up with, that's not what you just said, though. You just said she was being detained for obstruction of a roadway. This says you were detaining her as a possible DWI suspect. Is that the truth? Because remember, I'm trying to get them back to what they were before. Mm-hmm. Her answer was yes. And then I cover it. And like we've covered before, you didn't even consider obstruction of a roadway until after you had a chance to talk to these DAs, right? Because now we're nailing her down. The officer can't get away from this. The only thing that has changed is the DA. So she tries to waffle. The officer does. I wouldn't say that was her answer. Would you agree with me that they are the ones that brought it to your attention? No, actually I did. So now she's trying to change her words. I'm like, well, then did you change your report? And she questioned me, why would I change my report? Well, did you change your report to say you were detaining for an obstruction of a roadway? Because that's what your report says, that you were detaining for DWI. She goes, no, I didn't. I say, well, then would you say your report is inaccurate? Because that's a sworn document, lawyers. The report is a sworn affidavit. That is under oath. You can use that. Well, no, I wouldn't say the report is accurate. I was like, but if you're telling us today that it's obstruction is the reason for detention, and you told us before and in your report that it was DWI, you don't think that that is inaccurate? No. So now we've made her look like a fool. Don't stop there. All right. Don't stop there. Okay. What I want to do is I'm kind of skip to the end here where we talk about the hunch, because that is the crux of this case, right? Ladies and gentlemen, if we're doing this motion to suppress as a practical exercise, we're trying to get the officer to come back to this is a hunch, just like we did in the ALR. All right. My question was, now at some point she was detained. You did not know whether or not she'd been drinking at all. Your answer was correct. So I'm reading it to the officer. Did I read that correctly? Yes, you did. And what crime were you detaining her for at that moment in time? Keep in mind, I've just read her what she said. I've got to get her back to only DWI is the reason for detention, because she actually would have a basis for detention based on obstruction. At what point? At the moment in time in which the window had not been rolled down, you're commanding her to roll it down, and you say she's not free to leave. What crime are you detaining her for? She said, driving while intoxicated. Boom, I've got her back, right? Now it's no longer obstruction of a roadway because I've read it to her again and again. So I've gotten her to the point where she can't deny this. So now it's back to DWI. And I say, so I want to be clear. At this point, she has woken up because you've knocked on the window. The window is still up. She is detained, and the sole basis for her detention at that moment in time is the possibility of driving while intoxicated. The answer was yes. Even though you had no information she had actually drank, you are detaining her for potentially being a DWI. Correct. We're there. We've got her back, ladies and gentlemen, all right? We've got her back by a consistent bombardment of her own statements again and again. The police report, the ALR, reading it for her over and over again because I didn't let her off the hook with just one time saying it was a DWI. I did it multiple times. Now that's not enough. We've gotten her back to this is a DWI potentially, not an obstruction. Now I have to get her to hunch. All right. And would you agree with me that that detention was more akin to a hunch rather than reasonable suspicion? Her answer was no. Well, now wait a minute. I read it for you earlier, Lacey. Mm-hmm. Did she say it was a hunch?
Yes.
And did she say it multiple times?
Yes.
In fact, if we go back to that, reading it for you, right? This is why we do these things. Would it be fair to say that I have a hunch that she's intoxicated? Would that be fair? Yes. And prior to detaining, prior to smelling the odor of an alcoholic beverage and the defendant rolling down the window, you were just going off your hunch. But after she rolled down the window, that's when you got reasonable suspicion. That was the words. So now I've asked, would you agree with me that you had a hunch rather than reasonable suspicion? She says no. All right, here we go again. Walk up there. My question, reading it for her, outlining it, would it be fair to say at this point, because you don't have any information regarding drinking, your detention is more akin to a hunch based on your experience and training. You had a hunch she was intoxicated. Would that be fair to say? And the answer was yes. Did I read that correctly? You did. And then only when she complied with your command to roll down the window, that's when you got the odor of an alcohol, not before. Correct. And then we ask the same exact question that we asked in the ALR. Now, prior to her rolling down the window, you were just going off your hunch. But after she rolled down the window, that's when you had the reasonable suspicion to confirm your hunch. Is that correct? The answer was no. Now, I haven't read this question. I just asked this question. I read her the previous one. So she again has doubled down and said, no, that's not correct. And then I go, have you ever said something to the contrary of that? No. Let me read it for you. And then I ask, and this is the same question, Lacey. This is why it matters. My question was, and I'm reading it for her, prior to that, were you just going off the hunch? But after she rolled down the window, that's when you had the reasonable suspicion to confirm your hunch, right? Your answer was correct. Did I read that correctly? Yes, you did. This is going back to me not reading now. Now I'm questioning the officer again. This is where you get them. Mm-hmm. They've done it at least 10 times throughout the course of this. I hadn't read all 10 of them, but they've done it a bunch. I say that's literally directly opposite to what you just testified to. Officer, would you say in this case, I have found at least 10 different instances where you have directly contradicted your sworn testimony? Ladies and gentlemen, this is what I'm talking about. You have to hold the officer to their word. If their words don't matter, then they shouldn't be officers because they are put in a position of authority, and you are illustrating this. But the way in which you illustrate this is you don't get on your soapbox in the motion to suppress hearing in front of a judge. Know your audience. Your judge doesn't care about the soapbox. The judge doesn't care because they hear the officers testify every day, probably hear the officers lie on a majority of the cases almost every day. And it's terrifying that the officers do this, but the officer is just like any other human. They are designed to try and support their conclusions, whether they be right or wrong. You need to illustrate this. Don't pound the soapbox in the hearing. Get the words so that you can use this. Because remember, spoiler alert, we lost this. How did we lose this? I have no idea, but we lost this, right? This hearing. So I asked the officer, to my count, you have at least 10 instances where you have directly contradicted your sworn testimony. Yes. Here's how you follow up. This is a play-by-play. This is how you follow up in those situations. Do you have an explanation for that? Lacey, where can they go? They have 10 instances where they've directly contradicted their testimony. Where can the officer go?
I don't think there's anything left to double down on at that point.
There isn't. Now, have you ever heard the lawyer should never ask a question he doesn't know the answer to?
No.
Okay. That's stated throughout law school. Never ask a question as a lawyer you don't know the answer to. Horse shit. Bad lawyers adhere to that because they don't know how to think on their feet. If you know how to think on your feet, then that is not a rule you should adhere to. It is a generalized rule for baby lawyers who don't know what the F they're doing. Now, I'm asking an open-ended question. Why? Because I want to hear the response, because this officer has already illustrated that she's not a very good liar.
Mm-hmm.
She's lying when there's no reason to lie.
She's not thinking on her feet.
I've got the oath. I've got the sworn report. I've got the ALR transcript, and she doesn't seem to care about any of those things. So anything that this officer says to justify it is going to be good for me. And I am thinking not in the terms of this hearing. Think about the war, not the battle. Sun Tzu. Think about the end game. The end game is I want to win this case. The end game is I don't want to impress this judge or make friends with the officer or make the prosecutor like me. Lawyers that do that are consummate losers. You must give the officer the rope to hang themselves with. Have you ever heard that saying?
I have.
All right. So we're giving him the rope. Do you have an explanation for it? You're never going to believe this. This is what was told to me. And this is told to me over and over again. It's crazy. Her answer, I would say that this was one of my very first ALR hearings. Remember, we used the ALR hearing over and over and over again. I've definitely come a long way in my training and experience since that point in the realm of hearing and testimony. Oh my God.
So she since learned.
She basically said, I've learned how to lie better.
Mm-hmm.
I couldn't believe my ears. So do we let him get away with it, Lacey? What do you think?
No.
No. So my question was, in your experience, and I said it just like this, and this is when you get mean. I said, officer, in your experience and training that you have come so far with, I said it just like that. Have you ever found it okay to give untruthful testimony? Think about that. She just said, when I asked, do you have an explanation for your untruthful testimony? She said, I've come a long way in my training and experience in the realm of hearings and testimony. I learned how to lie better. So we focus their point on it and say, oh, in your training and experience, you've come so far with, you mother trucker. Have you ever found it okay to give untruthful testimony? The answer, of course, is going to be no, sir. Do you think I let him off the hook after that?
Nope.
Nope.
Nope. Mark hammered him.
In your experience and training to the point of that ALR hearing, because remember, it's the first, were you always trained as an officer to be truthful in sworn testimony? You know what the answer is? You're going to say, yes.
Mm-hmm.
Think I let him off again?
Nope.
And as a young officer, wouldn't you agree with me that it behooves you to make sure that everything you say is accurate to the best of your ability? Yes, to the best of my ability. Why does that matter? Because young officers are young. They are bright-eyed and bushy-tailed. They are there for justice. Justice means truth. That's what we're after. We're not after, in the realm of experience and training, how to twist the truth to make it legally acceptable. Do you think I'll let them off after they said, yeah, we're supposed to tell the truth?
Nope.
And no experience or training takes the place of the truth. Isn't that right? So what have we done? Lawyers, listen to the goal that you will be given on an open-ended question like that. You just heard the officer say, I'm going to give you the excuse of, I didn't have any training and experience to basically lie better. And every question after that I followed with, in your experience and training, it's never okay to lie. They didn't teach you to lie. You're never supposed to lie. And training and experience never takes the place of the truth. Now, what have we also done here, Lacey? What would you say if I have found, what do we call that when you catch a person lying under oath? What is that?
Perjury?
Perjury. Perjury is a felony in the state of Texas. You are not supposed to commit perjury, but if we're reading this correctly, which I like to think that I can read, this is directly from the officer's mouth. By the way, I didn't stop there either. I said, so if you were given an oath to tell the truth in an ALR hearing, you've consistently said that you were, and you said you told the truth in that hearing, right? Right. You have to agree with me that today's testimony has been significantly different than that hearing, right? She goes, I wouldn't say significantly. Oh, I love it when they fight me. Like, you got to be me right now. I found 10 different direct contradictions. I was like, just in the last question, they're polar opposites. Just in the last question, I asked you the very question and even read it, and you said it wasn't true. And then I read it for you, and you said it was true. Those are polar opposites. And the officer goes, they could be. Don't let them off the hook. They could be. Either they are or they are not. In one instance, you said you had a hunch. In the other instance, you said you didn't. Those are completely opposite answers, are they not? Don't let them off the hook. Yes, they are. Right? So we go back to, we use everything that they say. You give them the rope to hang them with. And when they say training and experiences gives me the license to lie better, we simply say, in your training and experience, you can't alter the truth. The truth is what it is. Training and experiences is literally that. If you're saying me the truth changes because of your training, you're telling me that training teaches you to lie. Mm-hmm. So what we have here is an officer admitting to perjury, a felony, right? This is why we do it. Ladies and gentlemen, lawyers, this is why you do it. Now, after that, the judge specifically ruled that the officer had reasonable suspicion to detain based on seeing a potential obstruction of a passageway, and that they had reasonable suspicion to detain based on the potential of a DWI. Even those are completely incorrect and inaccurate legal decisions. That's what the judge decided. I hate to break it to you. I told my 9-year-old yesterday when we lost a soccer game due to a bad referee, judges aren't always fair. Life isn't fair. Get over it. You know, there was this military guy. I think he was on the Joe Rogan show. And I saw this clip of him. And every time one of his soldiers would come to him with a problem, do you know what he would say, Lacey?
What?
Good. Why would he say that? If you came to me with a problem, Lacey, you said, hey, Mark, we can't record today. We can't do a podcast. The equipment's broken. What would you do if I said Good.
I don't know. I wouldn't be expecting that response.
Right. You'd be like, what are you, how can that be good?
Yeah.
Do you know why it's good?
Why?
Because it gives you a chance to overcome a hurdle, an obstacle. Okay. Good. We'll be better next time. Good. We'll make sure that we have the equipment ready an hour ahead of time so we don't waste time. Good. We learned something.
Mm-hmm.
As long as you learn something, it can be good. Right? So when I hear something like this, you know, the judge says, hey, we're going to deny your motion, even though for these BS reasons that are not based on the law, because the judge doesn't bother to look at the law. And even though I present him with the law and I underline it and I highlight it and I say, this is what it is. You cannot change the law. It is factually what it is. We should win, judge. And the judge doesn't give it to me. And my client goes, hey, why is this? Why did we not win? And I said, it's good. We got the officer to lie on the stand. We're going to get a copy of that transcript. And in that trial, we are going to overcome bad judges because now we're going to a jury. And that jury is going to look at this evidence and they are going to say, we're not okay with this. In fact, that officer should not be an officer. And you know what else is good? When I'm done with that officer will probably be fired. They will never, ever be allowed to arrest anybody again because they are okay with what?
Lying.
Perjury.
Perjury.
Lying equals perjury under oath. And do you think I just sat there before the trial and did nothing? No, what we did is we went out and got the transcript. So now I have the ALR transcript. I have the motion to suppress transcript. You today have heard those two things. This is not an uncommon exercise, ladies and gentlemen. This happens in almost every case if the lawyer does the job correctly. Go back and look at why you should hire us versus somebody else, or looking at why this lawyer versus that lawyer. Do they do the things they need to do right to give you the best chance at winning? Because if they don't, you have just offered up yourself to whoever your friend referred you to, rather than actually looking at it, doing an analysis yourself and say, should I hire this guy? Is this thing true? Does this person give me the best chance to win? I'm guilty of the same thing. I get a referral from my doctor. I go to that doctor. I don't challenge that doctor. The doctor that did the surgery on me, that gave me the diagnosis, may be one of the worst doctors in his entire graduating class, but I didn't check on that, and that's my fault. If your life is on the line, you would check. Your life is on the line in criminal defense, ladies and gentlemen. So we do the work. We have the transcript. We didn't just sit there. We went to the DA and we said, you have a problem here. We can go forward with this, because keep in mind, now we have to set the case for trial. So in the trial, I illustrate to the DA, this is what's going to happen. You know what the DA told me? Jump off a bridge, do your worst. That's not what a DA is supposed to do. The DA is hired to do justice. They are not hired to promote and promulgate lies of the officers. There was a way with which this officer could have done everything correctly. They just were untrained and didn't. Doesn't make the officer bad, but you know what does make the officer bad? Justifying it. Own your mistakes. If there are any of you that are going to testify in any sort of hearing, be truthful and own your mistake. The jury will like you. The judge will like you better because you did so. If I make a mistake, I own it. Do the same thing. So this officer just wasn't willing to own it. So what we did was we illustrated that to the DA. DA would say, jump off a bridge, I don't care. So we set the case for trial. This case was pending for nearly 2 years. The nursing license hanging on the balance. And we showed up for trial, and you know what they did, Lacey?
Dismissed.
They handed me a dismissal and said, this is the right thing to do. And then they acted like they were the ones that got there. I was like, hell no. I pushed you to this point. You knew what I would do, but let me ask you, do you think, Lacey, that they would have done that if it wasn't for my constant persistence in saying, look at this, you can't win, but if you force me to, I will make your office look bad. I will make this officer look bad, and to the point where they can't use her anymore. And to this DA's credit, this DA was a brand new DA that had looked at the case. And this just shows you justice is is not blind. Justice is in the eye of the beholder. And one DA looked at this and told me to pound sand. And the next DA that looked at this and was actually going to have to take the case to trial said, you know what, Mark? I'm not a fan of this. This is wrong. I'm going to dismiss the case. And that young DA held to her ethical high ground. And I give her props for this. She said, I'm not going to put a person that I think committed perjury on the stand. And guess what, ladies? That's an ethical violation. If you put a person that you think is going to lie on the stand, that is an ethical violation as an attorney. We are not supposed to do that. All you guys out there that think attorneys just throw mud against the wall and see what sticks, let their clients lie, knowing it's a lie, throw out completely irresponsible ideas or defensive theories just because it's the way to win the case. No, ethically, you cannot do that. I served as a judge on the Ethics Commission for 6 years here in Dallas. You cannot do that, or you can have your law license taken away. So this young lawyer recognized that her law license was in play if she were to put this officer on the stand. And I appreciate and respect the way that she went about things, because even supervisors told me to pound sand and said, no, we're not going to dismiss. And she dismissed the case. So this is a perfect example of how we used an ALR. Then we did a motion to suppress prior to trial. Now, if we had done this motion to suppress in trial and it was denied, then you're just going to a jury and you're hoping for the right result. Remember, the jury might hear about all the bad facts. They're going to see a person that looks intoxicated, that's passed out behind the wheel at nearly 3 a.m, that has a high blood score. All of these can lead to a loss unless we did the job right. And in this case, it all worked out because we nailed down the officer with the right questions. We didn't just let the officer lie. So what we're going to take away from today in motions to suppress is, if you do the ALR correctly, and sometimes you're not going to have an ALR, if you do the motion to suppress prior to trial, in my opinion, that gives you a better chance to win, because you get another shot at the apple. You might win the motion to suppress and they might appeal. Even if they appeal and you lose, you can still go to the jury with the same motion. So take as many shots at the apple as you can. Take as many chances to win as you can, because even if you don't, good. We're going to get that transcript. We nailed that officer. If your lawyer did their job correctly, there are going to be things they can use in that transcript. Pay for that transcript. Yes, it's a charge, a few $100. Get that transcript, utilize it to win the war, not the battle.
Mark Lassiter does the hard work. He pays attention to the details and gets the answers that you're looking for. You're not scared to ask open-ended questions because you still know the answer and the outcome that's going to happen anyway. How can people get a hold of you, Mark Lassiter?
They can reach me online at www.lomtl, or you can reach us by phone at 214-845-7007.
And if you're in need of a criminal defense attorney, you do offer free consultations, correct?
We do offer free consultations.
And you want someone who's going to work that hard for you. And that's what Mark Lassiter at Lassiter Law will do for you.
ProPod Digital.